It is a case so disturbing, it has prompted public outcry and protests from teachers.
12-year-old Gavin Peterson of West Haven died due to abuse and neglect.
The story begins with a woman whose obsession would one day lead to tragedy. Nicole Scott was determined to have a man she couldn't stand to share. Not with his past, not with his children. Shane Peterson was younger, handsome, and had a steady income. For Nicole, he was the prize. And nothing, not his wife, not his 3 kids, was going to stand in her way. She manipulated her way into Shane's life, using charm and persistence until she tore apart his family. But once she got what she wanted, she realized she had inherited more than just a man. He brought along 3 children, 2 girls, and a little boy. Her hatred for their mother quickly extended to the children themselves. Over the next 10 years, Nicole left deep emotional scars on the oldest, shattered the spirit of the middle child, and slowly, methodically destroyed the youngest. What happened inside their home was a quiet nightmare no one saw coming, until it was far too late. 8 months after Gavin Peterson's heart stopped, in March of 2025, all 3 adults involved in his death stood before a judge. Each of them had a chance to stop what was happening. Each could have given him water, a bite of food, or said, "Enough." But none of them did. And so, we tell this story, not only to remember Gavin, but to expose the system that failed him and the people who watched him fade away. If you're watching this now, drop a comment with the time of day you're tuning in. It helps me know the best time to post these stories. And please subscribe. More people need to hear what happened to Gavin. Gavin was born on January 15, 2012, in the quiet city of Ogden, Utah. He was the youngest of 3, joining his older brother Tyler and sister Melanie. Their parents, Melanie and Shane Peterson, seemed like any ordinary couple. Gavin was bright, curious, full of laughter and joy. He loved space, Pokemon, his Nintendo Switch, and his favorite color was blue. But the family's calm appearance was hiding something much darker. In August of 2014, Gavin, then just 2 years old, was found wandering alone near his home. When police entered the house, they discovered a pipe used for illegal substances left out in the open. Gavin's mother, Melanie, was charged with creating an unsafe environment for children. By November of that year, she pled guilty and was sentenced to community service, therapy, and parenting classes. She took the court's orders seriously, completed her service, paid the fine, and finished both mental health and substance abuse programs. By mid-2015, she had a stable job and did everything the court asked of her. "I took all the classes," she later said. "I knew I needed help, and I did what I had to do to get my kids back." But no matter how hard she tried, Melanie was never granted custody again.
"I'm trying. No one helped me."
During that time, Shane had remarried, this time to Nicole Scott. Nicole didn't just dislike Shane's ex-wife, she hated her. And that hatred extended to the children, who served as constant reminders of the life he once had. Nicole was careful, calculated. She didn't openly abuse the kids at first. Instead, she worked behind the scenes, starting with Tyler, the oldest, who had autism. She showered him with privileges the others didn't get. Slowly, she turned him against his siblings and his mother, making him an ally in the abuse. Melanie, the middle child, would be next. As the girl grew and began to look more and more like her mother, Nicole's resentment deepened. By the time Melanie was 13, life in the house had become unbearable. Nicole installed surveillance cameras in the bedrooms. She beat Melanie with a belt or wooden spoon and once even zip-tied her to the bed. Melanie had to ask permission to do basic things, take a shower, brush her hair, even use the bathroom.
They manipulated me into hating my mom.
"I found a comb on the floor once and started brushing my hair," she recalled. "She got mad. That's when she shaved my head." When 6-year-old Gavin came home that day, he froze in the doorway at the sight of his sister. Head shaved, face streaked with tears. "It's me, Gabby," she whispered, trying to smile. But the boy took a step back. "See? Even your brother thinks you're ugly, Nicole sneered. In the corner, Tyler laughed. It was exactly what Nicole wanted. To divide the siblings, isolate them, and make sure they had no one to lean on but her. 𝐬𝐿oni became a maid in the household. She did hours of yard work, both at home and at Nicole's grandmother's house across the street. Despite the physical labor, she was barely fed. Most days, she and Gavin were given only bread smeared with mustard, something they both hated. Nicole knew that. That was the point.
The same thing Gavin did. Bread with mustard. I can't go there.
In March 2019, a concerned friend of 𝐬𝐿oni's reported the suspected abuse. A DCFS worker showed up, but instead of taking action, they created a safety plan that simply said, Nicole should not be left alone with 𝐬𝐿oni. The situation only worsened. In April, 𝐬𝐿oni tried to run away to her mother's house. Shane and Nicole caught her near a gas station. On the way back, she says, Nicole strangled her in the back seat. After that, 𝐬𝐿oni wasn't allowed to finish the school year. Nicole told her she was being punished, but the truth was more calculated. Her bruises were too visible to hide.
I was deathly terrified to go back with them.
Nicole couldn't risk teachers asking questions, but fate shifted on Memorial Day weekend in May 2019. 𝐬𝐿oni was accidentally broke a sprinkler while mowing the lawn. Shane told her to get in the car, but instead of driving to the store, he took her to her mother's house, left her there without a word, and drove away. Seeing her daughter's frail body and shaved head, 𝐬𝐿oni's mother called the sheriff. DCFS was contacted again, and interviews were conducted. But once again, no investigation followed. By November of 2019, Melanie had finally won the right to see Gavin every other weekend, and what she saw terrified her. Gavin looked sick, thin, pale, sunken eyes. In February 2020, she took a photo of him without a shirt. His ribs were clearly visible beneath his skin. She documented everything and went to CPS. But once Shane and Nicole found out, they struck first, filing a complaint against her. Visitation was suspended. The dragged on with the pandemic, and 𝐬𝐿oni never saw her little brother again. That February visit was the last time. With his sister gone and no contact with his mother, Gavin was left completely alone. Nicole's full attention turned to him, and the abuse escalated. School was the only place where he found brief moments of peace. But even there, the signs of what was happening couldn't be ignored for long. By the 2021-2022 school year, teachers noticed the changes. Gavin, always a small kid, now looked frail. His hair was buzzed short, his eyes dim, his body hunched. He missed more and more classes. No one knew the full extent of what was happening, but everyone sensed something was deeply wrong. And tragically, the worst was still to come. One woman at school couldn't ignore what was happening to Gavin. Jan, who worked in the cafeteria, noticed something deeply troubling. Gavin would take a small cup of water, walk over to the trash can where students tossed their leftover food, and quietly search for scraps to eat. The sight of a child so hungry he was willing to dig through garbage haunted her. Jan and another cafeteria staff member began secretly paying for his meals, even though it went against school policy. The administration insisted that any struggling family should apply for free meals, but this wasn't about money. Shane had a steady income. The problem was at home. Nicole was purposefully withholding food from Gavin. When she discovered that someone had added funds to his lunch account, she stormed into the school, furious. She demanded they stop feeding her stepson and insisted that only she had the right to decide when and if he ate lunch at school. Just days later, Gavin showed up with a chipped tooth. Staff initially thought he'd taken a fall, but it was later revealed to be another sign of abuse. By the 2022-2023 school year, Gavin, now in 5th grade, had visibly deteriorated. Starved and desperate, he began stealing breakfast from other students. Teachers and classmates, seeing his condition, started sharing their meals with him. Cafeteria workers, unable to officially provide him with lunch, quietly gave him food from their own plates. For months, staff tried to raise the alarm. They were told that only the school principal could submit a formal report. When that changed nothing, Jan and others called Child Protective Services directly. Still, no action was taken. Then, in August 2023, the worst-case scenario came true. Nicole pulled Gavin out of school, claiming she would homeschool him. For a boy who loved learning and found safety in school, this was a devastating loss. Now, he was completely cut off. No school, no meals, no one to speak up for him. After that, no one heard from Gavin for nearly a year. Dozens of reports were filed with CPS, but not one led to a home visit. No one came to check if Gavin was actually being educated. The system failed him again and again. Jan and the other school staff often wondered about Gavin, hoping he had been placed in a safe environment, but they had no way of knowing. They clung to hope, unaware of the unimaginable reality behind the Petersons' closed doors.
There were coworkers that knew kids in his neighborhood that were asking, have you seen him? Has anybody seen him? Did anybody see him all summer? And from the last day of school on, nobody at the school that I know of saw him.
Gavin was being kept in an empty room with almost no furniture. No carpet, no bedding. As he grew weaker, he sometimes couldn't make it to the bed and would lie directly on the floor. He was forced to wear diapers, which often weren't changed for days. He couldn't use a bathroom, bathe, or see a doctor. His daily meals were barely enough to sustain life. A third of a cup of water and a slice of bread smeared with mustard, which he hated. Some days, he wasn't fed at all. Nicole kept a plastic piñata bat and used it as a tool for punishment. Like she once did with Gavin's sister, she watched him constantly through surveillance cameras. Any attempt to move, search for food, or even stand up resulted in punishment. Day by day, Gavin's little body withered. Open sores began to form and refused to heal. His body was failing, and his spirit, worn down by isolation and constant abuse, was fading too. On July 9, 2024, a 911 call was made from the Peterson home. A child wasn't breathing. Before help arrived, Tyler had sent a text to his father, asking what he should do about Gavin's condition. Paramedics found Gavin on the bathroom floor, cold to the touch. His body had already begun to stiffen. Shane and Nicole told emergency responders that Gavin had been throwing up for days, but was never taken to a doctor. Nicole claimed she had found him covered in vomit and helped him shower, but it was too late. At the hospital, doctors declared Gavin dead. Even seasoned ER staff used to trauma were stunned by the sight of his body. Some were brought to tears. The attending physician later said that in 20 years of medical practice, he had never seen a case of such severe malnutrition outside of war zones or famine-stricken areas. Gavin's body was a map of long-term systematic torment. At just 12 years old, he weighed less than 60 pounds, about the average weight of a 6-year-old. His skin was paper-thin, stretched tightly over protruding bones. His stomach was sunken, and his ribcage jutted out sharply. His muscles had wasted away as his body tried to feed on itself to survive. Patches of hair had fallen out. His back and hips were covered in sores from lying on a hard floor. His fingers were swollen, his hands bloodied. Some of his ribs had been broken in the past and healed incorrectly. Several teeth were chipped or missing. Deep bruises covered his body, especially around his wrists and ankles. Signs he had been restrained. The official cause of death was starvation, compounded by physical abuse. In a country where food is so abundant that waste is a daily issue, where even low-income families have access to food banks, a child in a middle-class home starved to death. Not from neglect, but from cruelty. In a home filled with surveillance cameras, full cabinets, and working adults, Gavin slowly faded away, and no one stopped it. When police reviewed messages between Nicole, Shane, and Tyler, they discovered something even more disturbing. Casual conversations about Gavin's punishments, jokes about beating him with the plastic bat, and decisions to lock his door and deny him food or water. Footage from inside the house showed Gavin, frail and skeletal, curled up on the cold floor, unable to move. When investigators searched the home, they discovered that Tyler had hurriedly removed cameras from Gavin's room and tried to hide them in a shed in the backyard. They also found prohibited substances, leading to additional charges against Nicole. But perhaps most chilling of all was Shane's complete emotional detachment from his own son. His co-workers didn't even know Gavin existed, yet his desk at work was covered in photos of the child he had with Nicole. All three, Shane, Nicole, and Tyler, were arrested and charged with child abuse homicide, aggravated child abuse, and child endangerment. Nicole faced additional charges for obstruction of justice and illegal possession. Gavin's death shook not just his hometown but the entire state. His story became a painful symbol of a system that failed again and again. Over the years, there had been at least 7 separate reports made to Child Protective Services, but none of them led to meaningful action. His mother, Melanie, heartbroken and devastated, spoke publicly for the first time after his passing.
The last time I saw him, I took a picture of him because he looked so skinny. Nicole trapped her in the room. The lock was on the outside. She couldn't get out, and she zip-tied her to the bed. There was a camera, so if she did anything, if she did get out, they would see it on the camera. I would imagine that Shane would let this happen, to starve him and let him die.
On July 23rd, the community came together to honor Gavin's memory. A vigil was held in his name, drawing a crowd of people, many of whom had never even met him. They stood side by side, holding candles and pictures of a boy they came to love through tragedy. It wasn't just about mourning Gavin. It was about grieving a system that had looked the other way. But even after death, Gavin's path to peace was full of obstacles. Legal confusion over burial rights stalled everything. Until Shane Peterson was officially stripped of his parental rights following his arrest, Melanie had no authority to make decisions about where to lay her son to rest. Only then could her family begin the legal process to bury Gavin next to his grandfather. By March 25, 2025, the legal proceedings began to move forward. Shane Peterson pled guilty to all charges as part of a plea deal to avoid the death penalty. His sentencing is scheduled for May 6th and could range anywhere from 8 years to life in prison.
Peterson decided to move this case forward and to resolve the case. I'm first going to hear from Mr. Whittison. He's going to put what the negotiation is on the record, and then I'm going to have some questions for you as we go through that, and make sure that everything's in order before I take any change of plea from you, okay? All right. Mr. Whittison?
Thank you, Your Honor. We are currently scheduled for a preliminary hearing in this matter. Mr. Peterson today is prepared to waive his preliminary hearing and enter guilty pleas. Mr. Peterson is prepared to plead guilty to counts 1, 2, 3, 4, and 5 of the amended information. And the negotiation with the state is that the state has agreed not to amend the child abuse homicide charge to murder or aggravated murder. And furthermore, the state and the defendant have agreed to recommend consecutive sentencing and imposition of the indeterminate prison terms at the time of sentencing. We have prepared a plea affidavit and reviewed that with Mr. Peterson in full. I've provided a copy to the state and to the court. The state has affixed its signature, and I've affixed my signature. Mr. Peterson is prepared to sign.
All right. Is that the state's agreement?
It is, Your Honor. I think before we proceed with the waiver, we probably should arraign him on the amended information.
And you've received a copy of the amended information?
I have, and I've also gone over that with Mr. Peterson. We'll waive formal reading of the information.
All right. Mr. Peterson, that amended information changes the counts that were originally filed. There's the same counts I understand that you're going to plead to today, and so let me identify what those are. Count 1 is child abuse homicide on a reckless basis, first-degree felony carrying a maximum sentence of 5 years and maybe up to life. Counts 2 is aggravated child abuse. It's a second-degree felony, carries a maximum sentence of 1 to 15 years in the Utah State Prison. and/or a $10,000 fine. Count 3 is aggravated child abuse, also a second-degree felony carrying same maximum sentence of 1 to 15 in the Utah State Prison and a fine of up to $10,000. Count 4 is a little bit different. It is aggravated child abuse, is a second-degree felony, but with the initials of a minor child of MP, carries a maximum sentence of 1 to 15 years in the Utah State Prison and a fine of $10,000. And then count 5 is endangerment of a child. That's a third-degree felony carrying a maximum sentence of up to 5 years in the Utah State Prison and a $5,000 fine. All of those charges carry the same offense dates, being arranged between January 1st of 2022 and July 9th of 2024. And all of those charges can run concurrent or consecutive with each other or with any other sentence that you may be serving time on. Now, you have a right to a preliminary hearing on all of those charges. The state would have to put on evidence to show that a crime has been committed and that there is evidence to support each of the elements of each of those charges. That hearing currently is scheduled for May, and you're entitled to that, or you can waive that hearing and go forward with a negotiated plea that we've discussed here today. Do you want to waive your right to a preliminary hearing?
Yes, Your Honor.
And you've talked with counsel about that?
That is correct.
All right, then I will accept that waiver and find that it's been knowingly and intentionally made. And the state consents to the waiver?
We do, Your Honor.
All right. Mr. Peterson, I want to make sure that you're going forward with your eyes wide open, recognize the maximum sentences, and really in terms of whether or not there's a prison sentence here, that you know that a prison term will be imposed by the court based on the negotiation and based on what's happened here, although we're going to wait and go forward with sentencing. I just want to make sure that you understand what your maximum risk is if you plead guilty here today. Do you understand that?
Yes, Your Honor.
All right, well, I think the state's prepared the statement in advance of plea. Maybe it was Mr. Whittison and Mr. Bichelle. But that document outlines the rights that you have and the waivers the court would need to accept in order for you to plead guilty today. Did you read that with your counsel?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
And do you have any questions about it before we proceed?
No, Your Honor.
All right, as part of this document, first of all, it outlined the charges that you're pleading to, the maximum sentences that go along with those. It identifies what the elements of the charges are, and then there's a page and a half that outlines the factual basis for these pleas. Are the facts as they are outlined in this document, are they true?
Yes, Your Honor.
All right, and then I'll rely on that for a factual basis. It also, Mr. Peterson, indicates what the plea agreement is here, and is there anything that you're counting on, that you're relying on, that is not included in this document or that we haven't talked about here in court today?
No, Your Honor.
All right, then I will acknowledge that. And as I said, I have final say in terms of whether or not these run concurrent or consecutive or how the sentences are imposed, but otherwise I will accept the plea negotiation. Finally, I think I looked at this. It does have the current language, the brand new language as it relates to withdrawing your plea. So that is current and I don't need to go over that. But do you have any other questions for your counsel or for me before I have you sign this document and before we take your plea today?
No, Your Honor.
All right. You are satisfied with the counsel that you've been given by your two attorneys?
Yes, Your Honor.
All right. Do you feel like you're thinking clearly today?
Yes, Your Honor.
And are you under the influence of any alcohol or controlled substances or medication that would make it difficult or impair your ability to make an informed decision today?
No, Your Honor.
All right. Mr. Whittison, any concerns on your part as his attorney?
No, none, Your Honor.
All right. And then, Mr. Peterson, if you're ready to go forward with your plea, I'll have you sign that statement in advance of plea. The attorneys will sign it as well. Once it's been signed by them, I will affix my signature to it, incorporate it into the record, including any oral statements that have been made here in court today. All right, Mr. Peterson, then to the amended information, count 1, child abuse homicide as a first-degree felony. How do you plead to that charge?
Guilty.
And to count 2, aggravated child abuse as a second-degree felony. How do you plead to that charge?
Guilty.
To count 3, aggravated child abuse as a second-degree felony. How do you plead to that charge?
Guilty.
And to count 4, aggravated child abuse with the initials of a minor MP. How do you plead to that charge?
Guilty.
And to count 5, endangerment as a child as a third-degree felony. How do you plead to that charge?
Guilty.
I'll accept those pleas, find that they've been knowingly and intentionally made, and I will enter the convictions for all 5 of those pleas. I do want a pre-sentence investigation report to be prepared by adult probation and parole. I think it's important, Mr. Peterson, although the fact that you're going to go to prison is a given in this case, I do think it's important that, first of all, you have the benefit of reviewing the PSI that's prepared, and you have counsel that can help you correct any factual errors. And in addition to that, that it include any information you want me to consider for purposes of sentencing. The state's certainly going to include any information that they want me to consider for sentencing. And then I want to know, part of what that document will tell me is what you're accepting responsibility for. And I think that's important for me to know as I make findings and determinations on the consecutive or potential concurrent sentence of any of those things. I know there's an agreement. I don't expect sentencing to take a long time because your counsel and you have agreed as to what that sentence might be. But I think I need to give it some thought. So I am referring it to APMP for you to go through the pre-sentence investigation report process. I expect you to cooperate with them. I also expect that you will give them any information they want, any information you want me to consider. And if you need any assistance, please consult with your counsel as you prepare for that. Ms. Toombs, were you able to determine if the 6th or the 7th worked better for sentencing?
For the state, it would be the 6th at 4 p.m.
And does that work for you, Mr. Whittison, Mr. Bichelle?
It does.
All right. So, Mr. Peterson, I'm going to set sentencing for May 6th. We're going to set that at 4 p.m. in person. I expect that the pre-sentence investigation report will be completed, and we will have it at that time. All right. I think that is everything. I'll have you go back over to the jail in anticipation of that sentencing. We'll make all of the paperwork here a part of the file, and that will be all for your proceedings today. Thank you.
Tyler's case was more complex. Due to his autism and mental health conditions, he was released into his mother's custody, pending a full psychiatric evaluation. A judge is expected to rule in April on whether long-term treatment might be considered in place of prison.
Those all have an offense date stemming on or about July 9th of 2024. Those are the charges that if you plead to those, all of those sentences can run concurrent or consecutive with each other, and I would have final discretion as to what the sentence would be and also whether or not it runs concurrent or consecutive. I want to make sure you understand and appreciate the maximum risk you face if you plead guilty today. Do you understand that?
Yes.
All right. Mr. Bichelle has prepared, or he has a statement in advance of plea to go over with you. Did you read that with him?
Yes.
Did you understand it?
Yes.
And do you have any questions about it before we proceed?
No.
All right. Do you think that you are moving forward today thinking clearly?
Yes.
Okay. Are you are you taking any medication or other substances that might impair your ability to make a meaningful and thoughtful decision today?
No.
All right. And are you getting any treatment over at the Weber County Jail? Mental health treatment or taking any medication there?
No.
All right. You have met, though, with some doctors. And is there any concern that any concern from you about going forward today?
No.
All right. Mr. Bichelle and the state included in the statement in advance of plea an outline of the elements of the charges that you're charged with in this case, and then also facts about what happened on or about July 9th. The facts that are included there, are those facts all true?
They're true.
All right. Then I'll rely on that for a factual basis. Mr. Bichelle, do you want to supplement the record anymore in terms of your understanding as to whether or not he understands all of this and that you think he is entering a plea that is in his best interest, and also that he knows what he's doing?
I would, Your Honor. Thank you. As the court and the state is aware, during the pendency of this case, we retained the services of Dr. Rick Hawks and Dr. 𝐃𝐨𝐵𝐿 to come and provide some assessments and some evaluations. We did a psychological evaluation as well as intellectual personality and an autism spectrum disorder evaluation. And from that evaluation, there were some findings that I can get into here in a few moments after we take the plea. But during that and speaking with both doctors and my own interactions with Tyler over the pendency of this case, I have no concerns that he does not understand what's happening. I have no concerns in spending the time with him that entering this plea is in his best interest. And so I would wholeheartedly agree that he is prepared to go forward today with the full mental capacity necessary to enter a plea.
All right. Do you have any other questions here, Mr. Peterson?
No.
All right, then I need you to sign that statement in advance of plea, acknowledging the rights that you have and the waivers you're giving the court prior to me taking your plea.
Okay, we're going to sign that page right there. Okay, then we're going to sign on the firearm restriction line right there. Oh, I printed that off weird, sorry. And we're going to sign one more right there.
So before you pass that to me, Deputy, Mr. Bichelle, will you look on page 1 under notification number charges? It says under 7716.
Right.
Will you just...
We already did that. We
You did
changed
that,
that
okay.
today.
All
Yeah.
right.
That's why I
Thank you.
screwed up. I was reading my own document and
Oh,
didn't put
okay.
the A in.
All right, and the attorneys have signed this. Mr. Peterson has now signed it. I'll affix my signature to it, incorporate the document into the record, including any oral statements that have been made here in court today. All right, Mr. Peterson, then to count 1, child abuse, homicide. It's a reckless mental state. It's first-degree felony. How do you plead to that charge?
Guilty.
All right, and count 2, aggravated child abuse intentionally or knowingly. How do you plead to that charge?
Guilty.
Count 3, aggravated child abuse intentionally or knowingly. How do you plead to that charge?
Guilty.
And obstruction of justice, a second-degree felony. How do you plead to that charge?
Guilty.
All right, I will accept those pleas. Find that they've been knowingly and intentionally made, and accept those pleas. Now let's talk about the special provisions that apply under 7716A 103 and talk about where we go from here. Mr. Bichelle?
Thank you, Judge. As we discussed earlier, Tyler did have an evaluation done, both by a psychologist and autism spectrum disorder specialist. And that evaluation came back with the diagnostic impressions that Tyler suffers from autism spectrum disorder, from generalized anxiety disorder, persistent depressive disorder, and, as Dr. Hawks indicated, other specified personality disorders with avoidant independent features. Because of that, under the statute 7716A 103, the parties, meaning myself and the state, can stipulate that he did have a mental condition at the time of the offense and that he could benefit from supervision or treatment. And under this statute, as we went over, because of this entry of plea under it today, the court can postpone sentencing until such time as an evaluation is completed and a recommended treatment plan is provided to the court as well. Given that the parties have stipulated, and given that I have spoken with representatives at Weber Human Services, which is required under the statute to provide said evaluation and treatment plan, that can be done within the next 30 days. That being said, that 30-day time frame would facilitate Mr. Peterson being released from custody. So our request would be, Your Honor, pursuant to this statute, he be released with any terms and conditions that Your Honor places upon him, including, but again, obviously not limited to, his availability to appear at Weber Human Services, to participate in the assessments which they will complete, and then the treatment plan that Weber Human Services will put forth for him. And we can probably have a review on that in about 30 days, according to Weber Human Services, to be able then to facilitate a further review on how treatment is going. I will let the court know, and I believe the state will have something along these lines as well, that while his release, he will live with his mother and his other siblings who reside in that home. I understand that that is somewhat tenuous upon Tyler being a model citizen and a model son and brother while he is residing in his mother's home with his siblings, and the state can address that more. So, Your Honor, my request would be today that we set a hearing about 30 days down the road. I'll make sure that Tyler gets over to Weber Human Services ASAP. I know we discussed being released also on pretrial level. I've explained to him what pretrial level 4 would be, which I think is appropriate. Honestly, and in full candor to the court, and getting to know Tyler and getting to talk with other individuals who know him, he's very regimented. I don't think there'll be any problems with him attending his treatments, attending any scheduled appointments, and even going to pretrial services on the required dates while we get through the things we need to pending the full sentence on this case.
All right, thank you. Ms. Toombs?
Your Honor, just a tiny clarification for the record. The state does agree that based on Dr. Hawks and Dr. Mendenhall's evaluation that Mr. Peterson does suffer from a mental condition that would meet the definition as articulated in 7716A103. In terms of whether or not the defendant could benefit from supervision or treatment, the court has had an opportunity to review the mental health evaluation provided by defense counsel, and there are findings there, and I think the court can make those findings. I'm not necessarily stipulating to those findings. I do believe that the assessment will ferret out additional information and is appropriate and is required by the statute. In terms of the request by defense counsel to release Mr. Tyler Peterson today, the state agreed to submit on that issue. I will note that the court did ask us to make contact with the mother, and I will have Ms. Pitt give you the report and representations on that.
All right, thank you. Ms. Pitt?
We've spoken with the mother and the Maywan, and they both agreed that yes, they would like him to come and stay with them at their home.
Okay.
But they don't have any concerns over that.
Okay. Any rules or regulations they wanted me to address for purposes of now? Okay.
I will just supplement with they will be in contact with our office if they have any concern. If any concern develops, then they will contact our office, and we will be back before the court to ask for reconsideration of that.
Would it be appropriate, and I'm sorry I didn't mention this earlier, to issue a pretrial criminal protective order? They are domestic violence related. First of all, they're family members, but they are representatives of the victim here. And I think pursuant to the pretrial criminal protective order, I could issue one of those that simply provides that there be no aggressive behavior, no domestic violence, and that then would be in the system, so that if there was any issue as far as law enforcement being called, they would have something that they could rely on instantly, in which they could detain Mr. Peterson. It would just be paragraph 1.
I don't have any problem with it.
Okay, I'll ask that the state prepare that and send that over. So, Mr. Peterson, there's a lot that needs to happen between now and when this case is over. This is an important first step, and I think that it has been some time coming. You've spent a lot of time in custody, and I'm recognizing, based on what I've been told and also the recommendations from what I'm hearing from your mom and your sister, that they are going to, they want you to come and be with them. But it is under some really strict terms and conditions, okay? And I want you to understand what those are. First of all, because you haven't been sentenced yet, I'm going to release you from the jail, but I'm going to release you to pretrial, which means I don't know that that will happen today. It might not happen until tomorrow. But if it does, either way, I'm fine with it. But the terms and conditions of your release are going to be these specific ones. First of all, no further violation of the law, whether federal, state, or local. 2, I am going to issue a pretrial criminal protective order on behalf of the immediate family members of Gavin, which means your mom and your sister, and I think that there's another sibling that lives there, and any minor children that might be in the house. And the protection order is that you commit no domestic violence, no threatening behavior, no assaultive behavior, nothing that would qualify as domestic violence. That means that if you are frustrated, well, you handle that in an appropriate way. I'm not necessarily worried about a specific risk. I just want you to understand what those terms are. If there's an argument and there are raised voices, well, then you need to extricate yourself or leave the situation and turn and walk away, okay? You don't even get in a loud argument with anybody. Second of all, you certainly don't put your hands on anybody in an aggressive or angry manner. And I want you to make sure that you are in control so that we don't have to revisit this portion of what I'm ordering you, okay? Pretrial also is going to supervise. That PLR-4 status means they're going to see you at the Weber County Jail twice. PLR-4 is only one time a week.
I thought we said 5.
Okay, PLR-5 status, they're going to see you twice a week based on their schedule. You're subject to all of the things that they may want you to do there. I am going to order that you have no controlled substances that aren't lawfully prescribed to you, and you are subject to testing for that. And I am just going to put you on a random basis that way. Again, not because there's a significant issue that's been brought to my attention, but because I don't want there to be any question that you are acting appropriately and you're only using prescriptions based on how the prescription is written. No creative use of any prescriptions, no alcohol, and no going in any places where alcohol is the chief item of sale. In addition to that, this isn't part for pretrial, but this is part of the terms and conditions of your release. You are to engage with adult probation and parole immediately to get started on a pre-sentence investigation report. I do want that information because eventually there is going to be a sentencing in this case. And I'll need that PSI. Second of all, I want you to engage with the Department of Health and Human Services through their appointee, which I assume will be the Weber Human Services. I want you to go through an evaluation pursuant to this statute. And the department is ordered to provide a treatment assessment of the defendant and submit to the court treatment recommendations for the defendant. And then we will talk about when we need to have sentencing. I'll just refer, as it relates to all of that, to Section 7716A 103 sub 5. I think all of it is included in sub 5 for purposes of what they need to do. And then I also need a waiver of the time for sentencing.
We'll waive that, Your Honor.
And so, because you're not likely to be sentenced within 45 days. Do you have any questions of what I expect of you while you are, or when you are released?
No.
And are you going to abide by those restrictions?
Yes.
Okay. Then I also want you to stay in contact with Mr. Bichelle. Make sure that he knows where you are. If you are to spend the night somewhere other than at your mom's house, first of all, Mr. Bichelle needs to know why and where, and so does pretrial. And then they will send that information on to me. Lastly, you need to sign any releases that may be necessary over at Weber Human Services. You make sure that those releases are signed over there so that they can send them to Mr. Bushell and frankly to the state as well, so that those can be transmitted to me. And I think that is all for purposes of today. Did we confirm April 24th at 2 p.m.? Does that work for everyone for a review of the treatment assessment?
Actually, Your Honor.
That's a Thursday.
Yes, that does work for the state as well.
Mr. Bushell, does that work?
It does, Judge. I may have one clarification question as well, if you have it.
Okay.
The order for Weber Human Services, will that be sent from here? Oh, so they understand?
So you need to draft that. You draft it? Okay. All right. Ms. Bick will draft it.
Okay.
And it will be sent over directly. It'll be made part of the file. You'll all have it, but she will transmit it as well. At least check in. I think that Dr. Mendenhall is aware enough of the situation that he can have a check-in with him immediately upon his release by tomorrow. But that evaluation itself may not be set up for another couple of days. You just be compliant with whatever they want. They say jump, you say how high, okay? All right, do you have any questions?
No.
All right. I think that is all on this matter, and I will see you, Mr. Peterson, with all of those things done on April 24th at 2 p.m., okay? All right, that will be all. Thank you.
Thank you, Your Honor.
All right, and
and
we are in recess then.
Nicole Scott, on the other hand, continued to claim innocence, despite the overwhelming evidence against her. She appeared in court in prison attire, cold and composed. Her preliminary hearing is scheduled for June 17th.
All right, Ms. Scott is coming out. Mr. Marshall is here on her behalf. Mr. McGahey and Ms. Toombs on behalf of the state. And counsel, I understand there's been a resolution, is that right?
That is correct, Your Honor.
Yes, Your Honor.
All right. Who wants to tell me about and put on the record what the resolution is? Mr. Marshall?
Your Honor, the state filed an amended information adding one count of aggravated child abuse to second-degree felony. Also, and this is the really important part, the child abuse homicide was amended to murder at first degree with mandatory minimum of 15 years to life at the Utah State Prison. So, Ms. Scott will be pleading guilty to count 1, murder, 1, 2, 3 counts of aggravated child abuse, all second-degree felonies, 1 count of obstruction of justice, 2 counts of obstruction of justice, also second-degree felonies, child endangerment, a third-degree felony, and then possession of a controlled substance, a Class A misdemeanor. Also, there is an agreement that there's a stipulation that all of these counts will run consecutively.
All right. And is that the state's agreement?
It is, Your Honor.
All right. Ms. Scott, I need to hear from you. Will you turn the other microphone, turn it around. Ms. Scott, you heard Mr. Marshall's explanation of what the change of plea would be to.
Yes, Your Honor.
And is that your understanding of the negotiation?
Yes, Your Honor.
All right. You understand, Ms. Scott. First of all, let's start with your right to a preliminary hearing. You do have a right to a preliminary hearing on the amended charges, and the amended information was filed, I think, just earlier today. Did you see a copy of the amended information?
Yes, ma'am.
And do you want to waive your right to a preliminary hearing on the amended information?
Yes, ma'am.
All right. I will accept that waiver and find that it's been knowingly and intentionally made. You understand that if you were to plead guilty to murder as a first-degree felony, that would carry a mandatory sentence of 15 years and maybe up to life at the Utah State Prison, comes with an optional $25,000 fine on the first-degree felony. On the 3 aggravated child abuse charges that are intentional or knowingly inflicted child abuse. Those are second-degree felonies. They carry maximum sentences of 1 to 15 in the Utah State Prison and a $10,000 fine. The 2 counts of obstruction, those are also second-degree felonies. Those carry maximum sentences of 1 to 15 in the Utah State Prison and a $10,000 fine. The endangerment of a child is a third-degree felony, carries a maximum sentence of up to 5 years in the Utah State Prison and a $5,000 fine. And the possession or use of a controlled substance is a Class A misdemeanor, carries a maximum sentence of up to 364 days in the Weber County Jail and a $2,500 fine. Now, I have final discretion as to whether or not those run concurrent or consecutive, but they can run consecutive to each other, concurrent to each other, or to any other sentence that you may be serving time on. I want to make sure that you appreciate the maximum risk you face if you plead guilty to these charges. Do you understand that?
Yes, Your Honor.
All right. You have had an opportunity to speak with Mr. Marshall about all of your rights and about how to handle this case. And I know that you have spent time talking to him about that and getting his legal advice. But the decision to plead guilty is your choice and your choice alone. Have you had enough time to speak with Mr. Marshall?
Yes, Your Honor.
And do you have any more questions for him today?
No, Your Honor.
All right. And you need any more time to process this?
No.
All right. I have to make sure, and I want to make sure, especially considering the weight of this case and the weight of the consequences here, that you're going forward with your eyes open, right? Not just about what the maximum is, but also what you're giving up. You're a little emotional today, and I'm not finding fault with that at all, but I need to make sure that you're thinking clearly today. Are you thinking clearly?
Yes, ma'am.
All right. And are you under the influence of any medication or any other substances that would make it difficult for you to make a weighty decision like this today?
No, ma'am.
All right. There's a statement in advance of plea that's been prepared. That document outlines the rights that you have and the waivers the court would need to accept before you could plead guilty today. Did you read that?
Yes, ma'am, I did.
Did you understand it?
Yes, ma'am.
And do you have any questions about it before we proceed?
No, ma'am.
All right, as part of that document, it outlines the elements starting on page 2, the elements of each of those charges that you're pleading to. Those are the elements the state would have to prove before you could be found guilty by a jury of your peers. But when you plead, you are relieving the state of the burden of proving those elements of the offenses. Do you understand that?
Yes, ma'am.
In addition to that, starting on page 3, there is a blocked several paragraphs that go into page 4 that talk about what happened in this case. Did you read that paragraph?
Yes, ma'am.
And the facts that are included there, are those facts true?
Yes, ma'am.
All right. Then I will rely on that for a factual basis. Finally, Ms. Scott, you understand that pleading not only relieves the state of the burden of having to prove those charges, but you're admitting that you are guilty. And in fact, you're telling me that you are guilty. Is that correct?
Yes, ma'am.
All right. If you don't have any other questions about your rights and the waivers that you're giving up, then I would need your signature on that document. The attorneys have signed it, but let me give you time to sign it. Today is April 7th. You can sign and date that. Did you change the plea withdrawal?
I did not. In regards to the Rippey decision, I did not make any adjustments to that portion of it.
Actually, I'm going to make an edit here then, and I want everybody to sign and review it.
Yeah.
Rippey decision. I think I can find it.
Marshall and Ms. Scott, if you'll stand. Ms. Scott, then to count 1, murder as a first-degree felony. How do you plead to that charge?
Guilty, Your Honor.
To count 2, aggravated child abuse, intentionally or knowingly causing that abuse as a second-degree felony. How do you plead to that charge?
Guilty.
To count 3, aggravated child abuse, intentionally or knowingly causing that abuse as a second-degree felony. How do you plead to that charge?
Guilty.
Count 4, aggravated child abuse, again, intentionally or knowingly causing that abuse. How do you plead to that charge?
Guilty.
Count 5, obstruction of justice as a second-degree felony. How do you plead to that charge?
Guilty.
And to count 6, obstruction of justice as a second-degree felony.
Guilty.
Count 7, endangerment of a child or endangerment of a child is a third-degree felony. How do you plead to that charge?
Guilty.
And count 8, possession or use of a controlled substance, a Class A misdemeanor.
Guilty.
All right, I'll accept those pleas, and for the record, the offense dates are January 1st through January 1st, 2022 through July 9th of 2024, or simply July 9th of 2024. All right, I will enter those pleas. Then Ms. Scott, enter the convictions on that basis of those pleas. I will find that your pleas have been knowingly and intentionally made. On that basis, we will strike the hearings that have been set out, and we are going to set this for sentencing. You can sit back down. Thank you. We did reach out to other counsel, and we're going to set a sentencing hearing at 2 o'clock on May 12th for purposes of sentencing, both for Ms. Scott and for Shane Peterson. I just needed to make sure I had the right first name. Those will be done in conjunction. We may divide them up a little bit if needs be, but they'll be on the same day starting at 2 o'clock, and all counsel have agreed to that. Ms. Scott, you're going to go through a pre-sentence investigation report process. That requires you to cooperate with adult probation and parole, and I'm ordering you to cooperate with them. Give them any information that you want me to consider for purposes of sentencing, and then also make sure that you give them any information that they want. I invite both sides to file a sentencing memo if necessary. Make sure that that is filed, since we're having that hearing on a Monday, filed early enough that all parties receive a copy of it, and the court can digest that and make sure that I can read through it and process it before the sentencing date. And then finally, make sure that if those sentencing memos, if it's appropriate that they be sealed, make sure that you file memorandums in support of that designation so that we can seal them if necessary. And I have spoken with counsel about why that may need to be the case, but certainly we will have most of the information available just as we would in any other sentencing hearing. There just may be some specific information that doesn't go out to the public in terms of some of that investigation. All right, Ms. Scott, I'm going to have you return back to the jail. Certainly, as I said, cooperate with adult probation and parole. And I think that's all. Ms. Toombs, anything from the state?
No, Your Honor.
All right, anything else from you, Mr. Marshall?
No, Your Honor, thank you.
All right, then we will be in recess. Thank you.
Thank you, Your Honor.
Meanwhile, Gavin's case sparked wider conversations. Lawmakers began debating reform. Representative Christine Watkins introduced a bill that would allow social workers to obtain warrants when there are repeated abuse reports. But by March, that proposal was still stuck in committee, just like so many other attempts to fix a broken system. Gavin Peterson died the way he lived his final year. Unseen, unheard, forgotten. A boy who once loved Pokemon and dreamed of space, who had the brightest laugh and adored the color blue, vanished under the weight of deliberate cruelty. His story is a haunting reminder that protecting children isn't just a personal duty. It's something our entire society is responsible for. In the quiet town of West Haven, a child disappeared before anyone could save him. And now, All that remains are photos, court documents, and the painful question of how we let this happen. Friends, if Gavin's story touched your heart the way it did mine, please give this video a like and share it with others. Let's make sure his voice is heard. Rest in peace, little Gavin.